The first case to come before the court this morning for video oral argument is Zackory Langin versus Sheffield Lake Board of Education. Both sides will have 15 minutes to present oral argument. Mr. Langin, as the appellant, you may reserve up to 5 minutes of those 15 minutes for rebuttal. If you wish to reserve some time for rebuttal, let me know when you get started. I'm keeping the clock and can keep you informed about the passage of time. Please don't use the names of any victims or minors, as we are both live streaming this and will be putting the recording on the court's YouTube channel. We have read the briefs and we are ready to proceed when you are.
Thank you, Your Honor. I would like to reserve 3 minutes of my time for rebuttal. Your Honor, if it may please the court, the issue before us is regarding a random suspicionless drug testing policy that was enacted by the Sheffield Lake Board of Education on September 28th, 2015. And as a result, I was no longer allowed to participate in track and field, cross country, academic and scholastic challenge, pep band, and student government. Foremost, I was first removed from the track team and then was denied participation in any other activities. And this policy covers random drug testing for any student that wishes to participate in any extracurricular activity within Brookside High School, or who wishes to park on school grounds as a part of their parking permit. And the consequences as a result of a positive drug test in this policy is for a first offense or violation, it is 20%. You're denied 20% participation in your activity, and you are required to attend counseling, and you have to provide 3 negative tests in 6 months. And the policy states that both the negative tests, or both any additional drug tests and the counseling, has to be at the student's and parents' expense. For a second offense, it is...
Mr. Langin?
Yes.
I'm sorry. You have such limited time. Can I direct you to a couple issues that I'm concerned about?
Yeah.
When the original complaint was filed, you were just finishing up your freshman year, right?
Yes, I was still a freshman at that point.
Okay. Okay, and your mom and dad filed it on your behalf?
Yes.
Okay. And then that was subsequently dismissed, and then another complaint was filed. And
Yes.
then I guess the third complaint was filed, but that wasn't filed. That was supposed to be filed with your brother, who was a year or two younger than you, Josh, I think.
Yes.
Okay, since he's over 18 now, I guess I'm okay. I shouldn't use that name either. But at any rate, so he's over 18. But when you filed the third complaint, who actually filed the third complaint?
I filed it on behalf of myself, and my brother was still under the age of 18 at that time, so my parents filed on behalf of him. He turned 18 July 4th of that
But he had
year.
already, yeah, but he'd already graduated from high
Yeah.
school. Okay, so you and your parents filed it. You filed it on your own behalf, and then your parents filed it on behalf of your younger brother, who had already graduated from high school.
Yes.
Okay, I just wanted to make sure I had the procedure correct.
And to that point as well, the trial court, in dismissing the case from 2017, noted that all discovery would be in full force and effect, which goes to my assignment of error 4 regarding the motion to supplement the record. And the trial court had also explicitly noted that they were aware that I was no longer a student, so that should not have been an issue regarding standing, or if it was, I should have been granted some sort of appellate rights as well, which the trial court in essence said that it would be able to still hear the case, because the 9th District through both the 9th District through Bear and the Ohio Supreme Court through Huffer had said that any any actions by a school board are of great and general public interest, and therefore it would hear the case on that ground. And the policy affects any student within the district who wishes to participate in any extracurricular activities. And the policy is also evergreen in nature, which means that even if a student is no longer participating in that extracurricular activity, they're still subjected to the policy. So it doesn't exactly tie to extracurriculars. It begins with extracurriculars, but even if a student participates in, for instance, cross country in freshman year and does not participate in anything else, they can still be drug tested senior year as a result of this policy. The trial court, in dismissing my claims, cited Vernonia, Earls, and Huffer. And I would like to note that the decision in Earls was specifically cited for the evidence of increased drug use in that specific school district. And that was the grounds that it was ruled that it was reasonable for that policy to be enacted. And there has been no empirical data that has been shown throughout the past almost 6 years now that gave rise to this policy being enacted. And there was only really anecdotal evidence from depositions of both the board members and the superintendent as to why this should have been enacted, and which would give rise more to why it should be considered why the discovery should be included to be considered as a part of this matter. And regarding Huffer, the trial court clearly misapplied Huffer when Huffer was regarding a student in wrestling practice where the coach had a clear indication and clear evidence that he was under the influence of some sort of controlled substance, and then required him to get drug tested. And the results came back positive. And this policy that was enacted by that school district was specifically for why or how administrators and coaches and teachers should go about looking for drug use and at what point they could, which involved some sort of reasonable suspicion, which resulted in Huffer ultimately being suspended and I believe expelled as well, which only, and this policy is said to be non-disciplinary in nature as far as academic suspensions, expulsions, or loss of grades. And the Board of Education in their brief cited two 9th District cases, Dankoff versus Ohio High School Athletic Association and Hawkins versus Walsh Jesuit High School, which were to go to show why this case should not be reviewed on the grounds of mootness. In Dankoff, the Ohio High School Athletic Association was specifically requesting relief that one student be restricted from the bowling team as a result of his transfer into that school district. Once that student graduated, there was no need to restrict that student anymore from participation in the bowling team as he was no longer a student. However, this case differs in the very strong fact that I have been asking this whole time for the drug testing policy as a whole to be stricken, and not just for me or myself, for the entire student body. And in Hawkins versus Walsh Jesuit High School as well, it was not similar factually, but similar legally. The requested relief was that the parent be notified of any activities that the student was going to be involved with, and then once the student was graduated, then he was no longer a student and no longer participating in any activities. And at this time, I would like to reserve the rest of my time for rebuttal.
You're at about 6 minutes. You'll be allowed to have 5 minutes for rebuttal if you wish.
Thank you.
Counsel for the appellee.
Good morning, Your Honors. May it please the court. My name is Mark Fusco, and I represent the Sheffield Lake City Schools in this matter. The trial court's decision dismissing the case on the basis of that the plaintiffs lacked standing should be affirmed by this court. Judge Carr, just to briefly address the one issue you raised, this was not filed pro se by Mr. Langin at the trial court. It was filed by an attorney on behalf of Mr. Langin and on behalf of Mr. Langin's mother and younger brother. It only became a pro se matter on appeal. Just a point of clarification.
So the third complaint was actually filed by an attorney.
That's correct, Your Honor. The same attorney that had filed the first two.
But it was filed. It was a new complaint. It was filed after both brothers had graduated from high school.
That's correct, Your Honor. The complaint, well, there's only one appellant in this case. So Mr. Langin cannot appeal on behalf of his mother or his brother. He's only appealing himself. So there's a single plaintiff. And in paragraph 62 of the complaint, it clearly states that Mr. Langin had graduated from high school more than a year before this lawsuit had been filed. So really the issue, this is not an issue where the case has become moot during dependency of the case. This is an issue that the plaintiff never had standing in the first place, because when the third complaint was filed, he had already graduated from high school a year before. There was no way that he was ever going to be subject to this random drug testing policy ever again. So the case is moot on that basis alone, and the plaintiff lacked standing to bring that action in the first instance. So you really don't even get to the, capable of repetition but evading review, because he wasn't subject to the drug testing policy when the case was filed, and he would never be subject to the drug testing policy again. And this was not brought on behalf of all students of the school district. It was not filed as a class action. It was filed on behalf of Mr. Langin, Mr. Langin's brother, and their mom. Those are the only three plaintiffs. They were only seeking relief for the three of them. This is not a challenge overall with the drug testing policy. These are three standalone claims, which is really now one standalone claim, and Mr. Langin doesn't have standing to bring that.
Counsel, I just wanted to clarify.
Yes, Your Honor.
In regard to the trial court's order, what was the date of the final appealable order when the case was actually dismissed? Do you remember?
I have it right here in front of me.
Because I want to make sure we're talking about the same order, because I don't have the docketing statement right in front of me now.
November 25th, 2020.
Okay, that's what I thought. Okay, so in regard to that, it looks like the court really was talking about issues of justiciability and mootness and not really standing.
I think justiciability, sorry, it's hard to say that sometimes, it really goes hand in hand with standing. It really goes hand in hand with standing. But yes, there was no live controversy to adjudicate before the court, because Mr. Langin had already graduated from high school a year before the complaint was filed. So there's really nothing for the court to consider. The court kind of, addressed the mootness and the justiciability hand in hand. It is a close test for both, but this claim doesn't satisfy the elements of being able to bring this controversy, because Mr. Langin had graduated a year before the lawsuit was filed. He wasn't subject.
Okay, when you
to
filed,
policy.
I'm so sorry. When you filed your motion to dismiss, did you raise the issue of standing?
I believe so, yes, Your Honor. Justiciability and standing and mootness were all wrapped together in the motion to dismiss. Along with, there's a separate claim for damages in this case, and the motion to dismiss was directed at that as well on the basis of political subdivision immunity. The school district is a political subdivision of the state. This is a governmental function. The plaintiff is not entitled to damages in this sort of situation.
Well, I understand what you're saying, but I guess I'm a little confused when I was reading your brief as well as reading the court's ruling. If it's a constitutional violation. You don't have immunity to violate people's constitutional rights.
You do not, Your Honor. However, there is no private right of action for money damages under the Ohio Constitution. There is under the federal Constitution, but that only as it relates to a Section 1983 action, and that's not the issue before the court. Ohio does not have a companion to Section 1983. So again, even if there was some perceived constitutional violation here, Mr. Langin would never be subject to the drug testing policy because he had matriculated a year before the complaint was filed. There's just simply no live controversy for the trial court to consider. And Your Honor, there was some discussion in the appellant's argument just now about the drug testing policy itself. That issue really isn't before the court. I mean, the merits, the trial court has never reached the merit. In 3 cases, the merits of the drug testing policy have never been reached. What the trial court did not opine on whether or not this drug testing policy was appropriate. What the trial court held is that these individuals could not bring this case to court because they were not subject to the drug testing policy. So even though we've had several years of litigation, there's been no decision with respect to the merits of the claim and the merits of the policy, and the merits of that policy are now before the court today. It's only the issue of whether this is a justiciable claim. And Your Honor, to go to the Huffner decision, just briefly, the Huffner decision was a decision on the merits of a disciplinary action enacted by a school board, which is completely different from the situation we have in this case today. That case was allowed to proceed because there was still a live controversy, unlike in this case where there is no live controversy. And if the court does not have any further questions, I would just ask that respectfully request that the decision of the trial court be affirmed. Thank you.
Thank you, counsel. Mr. Langin, you have 5 minutes remaining.
I would just like to point out that the specific requested relief in my complaint through all 3 cases was that this policy be ruled unconstitutional on its face, which even though I was not bringing it on behalf of all students, thus affects the entire student body, as if the drug testing policy is to be found unconstitutional, it would affect all students, as it would no longer be allowed to be enforced as it is. And I would also just like to point out that the trial court, again, in dismissing the 2017 case, noted that it is undisputed that Zackory is no longer a student at Brookside, as he apparently graduated in 2018, and still noted that the case was of great and general public interest and would have allowed to hear it on that grounds, but for the second amended complaint, which would have included my brother, and that would entail an likely discovery according to the trial court, which prompted them to dismiss it over my objections and forced me to file a new complaint. And I would also just like to note that this has seemed misleading by the trial court in the essence that the 2017 case was dismissed, and the trial court made it appear that they were going to hear the case on the merits as a result of the Baird decision, which notes that the school board authorities of great and general public interest. And so I did not feel the need to appeal the 2017 case at that time. However, I believe that if you guys find that I do not have standing in this 2020 case as a result of me no longer being a student, that I should be granted leave to appeal that 2017 case, as that was initiated when I was a student. And if the court has no further questions,
I just have one. I'm looking here and I'm trying to make sure I understand. So the third complaint that you filed and that your parents filed on behalf of your brother, because right now I don't have complete access to the Lorain docket. So we will look into all this and get it all situated, but eventually we'll have direct access, but right now we don't. Anyway, my question is, did you file yours under the same case number that was the original case number, or was it filed as a completely new complaint under a new case number? Do you remember?
It was filed under a new case number. It was filed under 2020 case number 20CA011710, and the original case was 17CA01941118. However, it was noted in the complaint that this matter had been that the 2017 case had been dismissed with the right to refile on both mine and the Second Amendment complaint's behalf.
Okay. And trying to think. I guess I just have one more question, and I'm just curious. Are you in school now?
I'm actually a senior at Cleveland State University.
Are you going to law school?
Hopefully.
Okay, I was wondering, because looks like you're, nothing in regard to the merits, Mr. Fusco, but it looks like he's a pretty good student. So I wish you well. Thank you.
Thank you.
Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision, which will be mailed to all parties to this appeal, as well as posted on the Ohio Supreme Court website.